A group of citizens gathers at Jantar Mantar to protest. Within a few hours, barricades are erected, police personnel are deployed, and later force is used to disperse the crowd. This immediately raises an important constitutional question. If India is a democracy and the constitution guarantees freedom of speech, why do people still need police permission to protest? And more importantly, can the state restrict protest at all? Hello everyone, my name is Rajni Jha. Welcome to Drishti IAS. In today's session, we will understand the constitutional philosophy behind right to protest in India. Let's get started. First of all, normally people think that democracy is just about elections, but democracy is much more than elections. Democracy has two components or dimensions. First is electoral democracy and the second is participatory democracy. In electoral democracy, we talk about elections. We talk about the fact that citizens vote in elections and they elect their own representatives. So the representation is through elected leaders. Whereas when we talk about participatory democracy, this talks about the participation or engagement of citizen in or with government or in the democratic process. So here, representation is done through protest, sit-ins, petitions, media and civil society. The Constitution does not view citizens as passive voters. In fact, it wants and expects them to participate continuously, to engage continuously. In fact, because of this, Supreme Court has repeatedly emphasized that dissent is the safety valve of democracy, which means dissent is absolutely important for democratic value in any country. Next, the question is right to protest a fundamental right? And interestingly, right to protect is not explicitly mentioned as a fundamental right, but it is derived from two rights that is under Article 19. So under Article 19, Clause 1, Subclause A and B, we have freedom of speech and expression and right to assemble peacefully and without arms. These two articles form the constitutional foundation for protests, marches, sit-ins, demonstrations, public campaigns. However, these rights are not absolute. They have restrictions. They have reasonable restrictions. State can impose reasonable restrictions on these rights. Let's understand Article 19 first. So in Article 19, we have 6 freedoms. How would you remember them? You can remember them with a mnemonic. Sam, and the spelling is S-A-A-M. Sam can reside anywhere. That means he can live anywhere. Sam can reside anywhere and practice any profession. Sam can reside anywhere and practice any profession. With this, you can remember all the 6 freedoms. First, Sam. S is speech and expression. A is assemble. Next, A is association. M is move freely. Reside anywhere. And last is practice any profession. So the first, as I told you, S stands for speech and expression. So in Article 19(1)(a), we have freedom of speech and expression. Next, A is assemble. So in Article 19(1)(b), we have right to assemble peacefully and without arms. Next, A is association. So in Article 19(1)(c), we have right to form associations, unions and cooperative societies. Next is M, that is move freely. So in Article 19(1)(d), we have the right to move freely throughout India. Next is reside anywhere. So in Article 19(1)(e), we have the right to reside and settle in any part of India. And the final one is practice any profession. So in Article 19(1)(g), we have the right to practice any profession and carry on any occupation, trade or business. But as you can see, along with these rights, these freedoms that we have, these 6 freedoms, we also have restrictions. So for Article 19(1)(a), which is freedom of speech and expression, we have Article 19, Clause 2, which imposes restrictions on this. Similarly, for Article 19(1)(b), we have restriction in Article 19(3), which imposes restrictions on right to assemble peacefully and without arms. So as I told you, we have right for peaceful protest from Article 19(1)(a) and 1(b). We also have restrictions which are given in Article 19(2) and 3, which are placed on protest. So under Article 19, 2 and 3, state may impose reasonable restrictions in the interest of sovereignty and integrity of India, morality, public order, security and decency. We will talk about this reasonable restrictions part in a while. So, next question is the constitution dilemma. What is the constitutional dilemma here? If we talk about this part especially, you think about it, Constitution gives citizens freedom, but at the same time expects state to maintain order in society. And that creates a dilemma. Imagine one group wants to protest and students want to go to school. Similarly, ambulance want that the road should be empty, free, right? At the same time, office goers, they want to go to the office. So whose right should be given priority? And Supreme Court is very clear on this, that the fundamental rights do not exist in isolation. Your freedom ends where my freedom starts. So how to make the balance of it? Because the constitutional dilemma is, the constitution has responsibility towards citizens. At the same time, there is responsibility towards society by the state. So responsibility towards citizen is they should have freedom of speech and we should protect that. They should be allowed to criticize government. They should be allowed to peacefully assemble or protest. But at the same time, the state should also maintain law and order, prevent violence, and ensure normal life continues. This creates a tussle, and we have to make a balance between these things, these responsibilities, also called civil liberties, and these responsibilities which lead to public order. So there has to be, the Indian constitutional law tries to make a balance, tries to balance civil liberties and public order. That is the dilemma here. Now, why did constitution makers did not make protest an absolute right? Now, as Supreme Court has been saying again and again, that dissent is the main backbone of any democracy, right? So why don't we have this right to protest as absolute right? Because absolute rights cannot be taken away. So why is this not absolute? And the answer to that is, Constituent Assembly during that time had witnessed partition riots, communal violence, colonial repression, revolutionary movement. There were a lot of revolutionary movements and mass mobilization in the Indian freedom struggle. So they understood two realities, that in democracy for it to survive, people should be allowed to dissent. People should be allowed to criticize the government. Dissent should be allowed. Without it, democracy will not survive. But at the same time, society can only function in order. So society cannot function without order. That is why they wanted a middle path. So they created the idea of reasonable restrictions, that government cannot suppress the protest simply because criticism is happening, simply because people are criticizing the government, but it can impose restrictions which are reasonable. And there are 3 tests for this, which we will discuss now. All 3 tests should satisfy, then only we'll call such restrictions reasonable restrictions. So this is the reason that they did not have absolute right to protest. Next is powers of police and district administration. So according to, under Bharatiya Nagrik Suraksha Sanhita 2023, district magistrates and police commissioners can restrict assemblies, impose conditions, ban gatherings temporarily, and issue preventive orders. And why would they do any of it? They can do this if they fear that there would be violence, or there will be riots, there will be public disturbance, or there is threat to life or property. Then they can impose these restrictions, so that timing can be regulated, route can be regulated, sound levels can be regulated, crowd size can be regulated, security arrangements can be made. As I told you, that everybody's right is important. So why would the rights of protesters should be such? Why should the right of protesters be such that they violate somebody else's right? Somebody wants to go to the office. What about his rights, right? So this is done so that these people can regulate timing, route, sound levels, crowd size, security arrangements. So can the police deny permission? Yes, they can deny permission. If, let's say, they have a credible intelligence about violence, that there is going to be a violence, or public safety is threatened, in that case, security arrangements are insufficient, or sensitive areas involved. In all these cases, permission can be denied. But as I told you, permission cannot be denied simply because people are protesting the government, simply because people are criticizing the government, simply because the views of people are against the government and the government is not liking it. It cannot be the reason. This has to be reasonable. The restriction has to be reasonable, and there are 3 tests for it. What are those 3 tests? First is legality, principle of legality, which means the government or police must have legal power to restrict or to act. Like in BNSS, these people, police can impose restrictions according to BNSS. It allows them to do so. So legality is there. Second, necessity. Force should be used only when the less severe methods did not work. So the police should first issue warnings, set up barricades before resorting to lathi charge situation. Next is proportionality. The action taken should not be excessive as compared to the situation. So if a small peaceful protest is taking place, excessive force, if it is used, it will be called disproportionate. So restriction has to follow all these 3 principles. Now the next question is, what are the important Supreme Court judgments regarding this? First is Himmat Lal Shah versus Commissioner of Police 1973 case, in which court said that the government can regulate public meetings, but the government cannot ban it completely. In the Mazdoor Kisan Shakti Sangathan versus Union of India case 2018, the court said peaceful protest is a democratic right, but it must be balanced with the rights of residents and commuters, the middle path that we talked about. Next is Shaheen Bagh case 2020, in which it was said that public roads and highways cannot be occupied indefinitely, meaning for a very long time or for forever, right? These protests must occur in designated space so that it does not affect the function of normal people living in a society or community. Next is, there is an interesting debate about the vision of protest. So there is Gandhi's vision and there is Ambedkar's vision. In Gandhi's vision, it says, protest against injustice is a moral duty. Satyagrah and non-violence make protest legitimate. And peaceful protest strengthen the democracy. So here, peaceful protest, he's talking about peaceful protest and how it is important for democracy. In case of Ambedkar, Ambedkar said that people should rely on elections, courts, parliament and constitution. He warned against grammar of anarchy, and constitutional methods strengthen democracy. Why is that so? See, according to Ambedkar, during the British time, we did not have constitution, we did not have democratic values, we did not have democratic system. So satyagrah, non-violence, protests, they were important because that was the only method for us to make the government listen to us, right? But now after independence, we have democratic system, we have constitution, and in that, because we have democratic system, we have democratic institutions, we should focus on constitutional institutions such as courts, elections, parliaments, etc. Right? Ambedkar argues that citizens should use these constitutional methods instead of constantly resorting to, say, protest or sit-ins or mass movements. So, did Ambedkar oppose all kinds of protest? No, he did not oppose all kinds of protest. He simply said that for everything, you should not be resulting in agitation or disruption. You should not be leading to agitation and disruption. For everything, protest is not required. You should resort to constitutional methods, constitutional institutions first. So what India is trying to do right now is, India is trying to maintain a balance between Gandhi's idea of peaceful mass mobilization and Ambedkar's idea of constitutional methods, Ambedkar's emphasis on constitutional methods. Right now in modern constitution, we try to negotiate between these two, we try to balance these two ideas. So there is a federal dimension also in this right to protest, which is police and public order. They fall in state list. So that means states make laws on these two subjects, right? So Delhi police may impose one set of conditions. Maharashtra may adopt another approach. Tamil Nadu may follow different rules. So different states may follow different rules because these are under state list. So while the right to protest is a nationally guaranteed right, its implementation varies across state, and that is the federal dimension of right to protest. Now the last part of this session, Jantar Mantar and lathi charge. See, people ask, if we have right to protest, then why the lathi charge? And that is not the question that we should be asking, because right to protest does not mean that force can never be used. But the real constitutional question here would be, was the police action lawful, necessary, and proportionate? Was the police action lawful, necessary, and proportionate or not? Because we have seen there are 3 tests for restrictions also. Police may intervene if protesters violate permission conditions. We have seen that. Enter prohibited zone, turn violent, block roads indefinitely, create law and order problem. But force should not be and cannot be used only because citizens are criticizing the government. So this action, Jantar Mantar action, whether it was justified or not, it depends on the conditions imposed, whether they were violating any rules, whether the protest remained peaceful or not, whether the police response was proportionate, whether the police response was lawful and necessary. So, whether particular police action is justified depends on the facts of that specific case. And right now, the real constitutional question is not whether or not we have right to protest, whether citizens should protest or state should regulate protest. Both are necessary. And for any democracy to survive, there are few things that are important. What are those few things? That the citizens can question power, the government can tolerate criticism, right? And police act impartially, and courts protect constitutional freedom. So citizens should be able to question the government should be able to handle criticism, police should act impartially, and courts should be able to protect freedom or constitutional freedom. So the challenge is to ensure that regulation does not become repression, right? Regulation does not become repression and dissent does not become disorder. The challenge is to ensure that regulation does not become repression. You can regulate, but you should not repress it completely. And the citizens, they can always protest, they can raise their voice. So the citizens, they should be able to raise their voice, they should be able to show dissent without it becoming chaotic. Dissent should not become chaotic. That is the main balance, that is the main challenge that we have to balance. All right. Next, okay, before we talk about the question here, I have also included one prelims question for you so that you can answer in the comment section. We have 50% sale going on, up to 50% sale going on until 22nd July on all live online courses, UPSC courses, PCS courses, teaching exams, judiciaries, SSC exam and CUET exam. And right now it is available at very affordable prices. So if you wish to be a part of us, please call on this number 87501 87501. I expect you all to join us. And now we move to the next part, which is the last session, which is the last part of our session, which is prelims based question, prelims practice question. It says, with reference to the right to protest in India, consider the following statements. The Constitution explicitly mentions the right to protest as a fundamental right. Second, the right to protest derives protection from Article 19(1)(a) and Article 19(1)(b). The right to assemble peacefully is available only if the assembly is without arms. And you have to tell me which of these is correct. Options are A, 1 and 2 only, B, 2 and 3 only, C, 1 and 3 only, or D, 1, 2 and 3 only. So that's it for today's session. I really hope that you enjoyed the lecture and you've understood everything that I was trying to convey. And until next time, take care.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.